Your Excellencies, distinguished guests, ladies and gentlemen, good afternoon and welcome to the Italian Academy. I am Barbara Faedda, the Academy's Executive Director. I welcome you all today, also on behalf of the Academy's Director, Professor Friedberg. I stand here today also in my second capacity, that is as permanent observer of the European Public Law Organization to the United Nations. I must say that it is a pleasure to see so many international diplomats from the United Nations in this room. As many of you know, the Italian Academy is a Columbia University Institute for Advanced Studies, stretching from the sciences and the social sciences through the humanities and the arts. The Academy serves as an independent forum open to interdisciplinary research that has an international scope. Every week, at the seminars of our fellows in residence, we start the afternoon with conversations about the most pressing current issues. And given the rich and diverse background and expertise of the fellows, we often compare and refer to different historical periods, different geographic areas, or different communities. Needless to say, the concept of rule of law comes up again and again, just as it does in everyday life. It couldn't be a more timely topic. This Academy and the European Public Law Organization are two institutions that have long been interested in the rule of law. The European Public Law Organization launched a program on this topic at the United Nations in 2019, and the Italian Academy produced an edited volume of 32 essays on this subject in 2021. On the European Public Law's commitment to rule of law, I asked Professor Flogaitis, whose brief bio you will find in your program, to say a few words. Professor Flogaitis?
Excellencies, dear professors, colleagues, students, it is with pleasure and honor that the European Public Law Organization is co-sponsoring this event. Indeed, some among the best lawyers of the world responded positively to the invitation of Professor Barbara Faedda and came together to discuss aspects of the rule of law in front of a high-level audience. The European Public Law Organization, also known as EPLO, international organization with headquarters in Athens, Greece, and offices in Rome, Italy, and Cascais, Portugal, is very proud for this. Established 16 years ago, the EPLO relies on a project which started more than 30 years ago and is bringing together scientific and reform forces of excellence from all over Europe and indeed the world. It aims at the promotion of public law in all its dimensions and governance, its study and its implementation beyond boundaries of any kind. It educates through the European Law and Governance School, the International University School established by the EPLO with headquarters in Rome, Italy, and campuses in Athens, Greece, and elsewhere. It has created a strong research community through the pages of its scientific periodicals, the European Review of Public Law and the Central and Eastern European Legal Studies, plus the more than 150 books published. It has produced reforms in more than 75 countries worldwide, with more than 350 projects up to date. Having been accepted as a permanent observer to the General Assembly of the United Nations, the EPLO, already well established as a promoter of the idea of the rule of law worldwide, took the initiative on 10 November 2023 to present to the Sixth Committee of the General Assembly its vision and concrete measures for serving more methodically the promotion of the rule of law at the planetary level. There are, of course, many other initiatives around the globe aiming at the promotion of the rule of law. And this is a sign that perhaps a better world will come up thanks to them all. For what concerns our humble contribution to the general effort, a Global Rule of Law Commission of the EPLO was created under the presidency of Professor and former Prime Minister Giuliano Amato, counting among its members some among the best personalities of the world. Ladies and gentlemen, please allow me to congratulate Professor Barbara Faedda for bringing the discussion for the promotion of the rule of law here today, in the heart of Columbia University, with a panel of no equal, and to promise that the EPLO shall always be there to contribute to the best of its capacity in such noble initiatives. Thank you very much.
Today we are grateful and honored to have a roundtable discussion with such a distinguished group of speakers, the most authoritative and competent legal minds of their countries, who traveled to be with us today. Their professional expertise and exceptional personal experience will provide us with the opportunity to reflect on the most urgent issues related to rule of law that affect all our lives every day and everywhere. The program will include a four-way discussion guided by the moderator and a brief final question and answer period. But now let me introduce the moderator of this conference. Jessica Ballman-Posen is the Betts Professor of Law and a Director of the Center for Constitutional Governance at Columbia Law School. She is an expert on state and federal constitutional law, federalism, and administrative law. In 2015, the graduating class of Columbia Law School honored her with the Willis Rees Prize for Excellence in Teaching. Before joining the Columbia faculty, Ballman-Posen served as an attorney advisor in the U.S. Department of Justice Office of Legal Counsel and as a law clerk to Justice John Paul Stevens of the U.S. Supreme Court and Judge Merrick Garland of the U.S. Court of Appeals for the D.C. Circuit. In wishing you a pleasant afternoon, I now leave the stage to Professor Ballman-Posen. Thank you so much.
Thank you, Professor Faedda, for organizing this wonderful event, and to the Italian Academy and the European Public Law Organization for sponsoring it. I'm going to first very briefly introduce our distinguished panelists. I've apologized to them already for the brevity of my introductions. You can find closer to complete, although still not complete, bios, including their many, many accomplishments and distinctions in your program. But in the interest of getting to the conversation, I won't take the hour and a half by introducing them. So let me, without further ado, begin in alphabetical order with Giuliano Amato, who is President Emeritus of the Italian Constitutional Court, where he served for the last decade. Before that, as you know, he was Prime Minister of Italy, as well as a member of Parliament, and served in other roles, including as a professor at several distinguished Italian universities. We also are delighted to be joined by Justice Susanne Baer, who just concluded her 12-year term as Justice of the Federal Constitutional Court of Germany. Professor Baer is also a teacher and scholar at Humboldt University in Berlin and at the University of Michigan Law School, as well as a director of the Law and Society Institute in Berlin. Justice Stephen Breyer served as Associate Justice of the United States Supreme Court from 1994 until 2022. He is now back where he began his scholarly career at Harvard University as the Byrne Professor of Administrative Law and Process, before serving for so many years as a distinguished justice on the Supreme Court. He also participated in government in several other roles, including as counsel of the U.S. Senate Judiciary Committee. And right next to me, we are delighted to be joined by Justice Ana Maria Guerra Martins, who is judge of the European Court of Human Rights since 2020. Before that, she served as a judge of the Constitutional Court of Portugal, and she too is a professor of law at the Law School of Lisbon University. So in addition to their public service, all of our panelists have written articles and books on the topic of the rule of law and related questions, and so I encourage you to look at their writings as well as to hear from them today. And as Professor Faedda indicated, I will leave some time at the end for your questions. But to kick off the discussion, I thought we could begin with the title of this convening, People, Rule of Law, and Supreme Courts Now. It struck me that there's an interesting tension or question about that first word in this title, people. We've seen across the globe in recent years invocations of the people through populist leaders, often popularly elected, but autocratic, trying to claim the mantle of the people to dismantle rule of law values, to undermine judicial independence in places like Hungary and Poland. At the same time, we've seen defenses of the rule of law from the people themselves. We've seen the people arguing for stronger rule of law values, for the protection of courts and democracy alike, in recent weeks, for example, in Israel. And so I thought we could maybe begin by reflecting on this relationship between the people and the rule of law today, and how we should think about the people, whether populism is the threat we should be worried about, whether people are necessary to the protection of the rule of law, and what, based on your experiences, which we can unpack further as the panel progresses, we should make of people, the rule of law, and Supreme Courts now. President Amato, maybe I could begin with you.
We follow the alphabetical order.
Not always, but maybe to start.
The age order. Whatever order you choose, I'm the first one, unhappily. Anyhow, something wrong with the microphone? No, I hope not. Well, you know, it depends on what you mean by the people, and this is the main problem with populism. Populism, as all of us know, is a movement of our times that has something to do with deep dissatisfactions in our population for several reasons, inequalities that have grown, but not only, also traditions that have been abandoned, individual rights that, according to many, have been protected more than it's useful for the community. Putting several things together, populist movements tend to say, we represent the people. Now, everybody says, I represent the people when he's an elected figures, etc. But there is an enormous difference between the I represent the people of a liberal democracy and the I represent the people of the illiberal democracy as Viktor Orban has defined his regime in Hungary. I represent the people means, in any liberal democracy, I represent the opinions that I now explain that are shared by others. I represent these opinions, this segment of society, this position on issues of public interest. And therefore, democracy is the sort of confrontation, somehow peaceful, among different opinions. And none of these opinions expect to be treated as the truth. This is the point. The leaders of the populist movements tend to say, we represent the general will of the people, the only will of the people, the only position that really the people feels. And the others are not legitimate opinions as the one that I embody. The others are the positions of the enemies of the people, the elites, the plutocrats, the immigrants, those who came from outside and want to steal what we have here. So this is clearly something that is a sort of deadly wound to the rule of law, because, to make it very short and very simple, the core of the rule of law that has several implications, but the core of the rule of law is the sense of limited power. The power has limits, and the rule of law sets the limits of the holders of power. If I represent the only possible will of the people, and whatever else is the expression of the enemies of the people, nothing can be above what I say expressing the will of the people, not even constitutional courts. Where constitutional courts do exist, they are the voice of the superior law that binds the holders of power. And if the holders of power cannot be bound, the Constitutional Court can only legitimize what they do. They cannot say no. They cannot declare something invalid. And if the courts cannot be abolished, the court can be transformed in such a way as to comply, they themselves, with the will of the people. This is basically the problem as we have it in several countries. Now, if we look at this phenomenon as something that begins inside the liberal democracies, and if you don't look at it as something that has already happened, is there, and you see the difference, there is a process, and there are ingredients that may be helpful, that may be used opposing the growth of populism. And here, perhaps, it's another point that reflects what courts can do either to prevent populist movements from growing or to somehow balance their strength in society. Here you see, like it or not, we go to something that all of the populist movements we are dealing with are using. The fact that liberal democracies only care about individual rights. They don't care about the communities. And individual rights is something that only the upper classes care, not all of us. We have something else to take care of. And it's not the only reason, it's one of the reasons, but it's where the courts find themselves exactly in sort completely involved whenever they are expressing the reasons of individual rights, and this creates a tension with communitarian positions. It takes time, and I don't want to use this time now, and I have already seen Suzanne that is not agreeing with me. So as long as we remain in liberal democracies, I want her to have immediately the necessary time to say, I disagree. What Giuliano said is not the truth, it's his opinion. This is a liberal democracy, my God.
I also noticed that reaction, so.
Well. First of all, I should echo what Giuliano Amato said in that, to respond to your question, the people matter in many ways to the rule of law, and this is not something that is always so clear as it was in the title of this podium. That's why I appreciated the title, because the rule of law is not an abstract concept out there or something boring, bureaucratic, or a nuisance to law students and practitioners, but the rule of law is protecting also not only a separation of powers and the limitation of power, but it protects people. And when the rule of law goes down the drain, it's people who suffer. And I think that would be always my first point to make. So, I think we agree on that. First agreement, I have to note these. Second, certainly the people is now abused as a code for an, in fact, exclusive, intolerant, rather limited notion of a majoritarian sentiment, opinion, whatever. So we face the threat of populism in the name of the people and, which makes it even more problematic, in the name of the law and in the name of a true court and in the name of the real democracy and all of that. So it's a very unfriendly takeover we are facing there. So that's the second notion where the people come in when we discuss the rule of law. Third, and I think what you mentioned is the people are, I think, the amici curiae, are the only friends, particularly Supreme Courts with the power of judicial review, have. And this means for courts that there is a task to explain what we do, to be as clear and ethically sound and reliable, etc., and trustworthy as possible, because we will need the people as now the real people, the citizens, the civil society, to back us up when political forces threaten the independence of courts, threaten the regulations, etc., etc. So that is important. Where I disagreed, or where I got a little nervous, my typical like, is where we locate the problems, the very complex set of causes that got us into this situation. And when I say us, who is that exactly? When we're talking from different countries and continents, the situation looks differently, and I would not want to, put them all in the same little bucket and pretend it's all the same. But around the globe, and particularly in North America and continental Europe and Britain and Australia and many Asian and African countries, I think we face a similar threat to the rule of law called populism. So what are the causes? Is the cause a notion of individual rights, which was maybe overdone or too limited to capture a sentiment, which is now bought in or used by populists to get public approval, as in community or community values or communitarian interests? And I'm not so sure why a German constitutional lawyer thinks of individual rights as always necessarily deeply embedded in community. There is no such thing as a liberal individual right that is not closely connected to everyone else around you. We call it proportionality tests, and there is no way to spend an evening as a lawyer without saying that word, proportionality tests. And why am I saying this? This is also not, again, an abstract, doctrinal thing, but it allows you to start with individual rights, which in post-fascist Germany was a very important notion, that you do not start with the state and the community, which was a völkische community of fascist Germany, but you start with the individual and his or her dignity. But you start with that to understand how it's situated in a community. The German Federal Constitutional Court, in one of its first decisions, said individuals are always socially situated and deeply embedded because it relates to other people. So there I started getting a little nervous, because I think individual rights, understood not as atomistic, egocentric, property claims, but as notions to protect each and every individual because they are humans, and then situated in society and assess accordingly who goes how far and what to do when, and I could, go back to philosopher Immanuel Kant, but luckily I can go back to many philosophers from around the world. It's not a German thing either. No. It's particularly a European Court of Human Rights thing, but the Inter-American Court, many courts use this notion. The individual is the starting point, but it's embedded in a community. So I would think one part of engaging the populists and fighting back is to clarify that individual liberal human rights are not the problem. They are the answer to a problem populism created. They are the response to a problem out there because they're there to protect people who are not in the majoritarian little, thing called das Volk, but in something we call society, which is diverse, but is based on respect for each and every one. So I guess, and I think we do agree on that one too, by the way.
more agreement than disagreement, but we have to hammer on the disagreement. Justice Breyer, could I bring you in to think more about the people, populism, but also the role of public opinion, which you've written about with respect to American courts? It seems to me that if we look at populism as a threat in Europe, obviously there are versions of that at play in the American legal system as well, but there's a distinct current concern, I think, about juristocracy, about courts having too much power, acting against the will of the people. In your most recent book, The Authority of the Courts and the Perils of Politics, you talked about public acceptance being key to the rule of law. That was written before Dobbs, before Bruen, before some recent developments and a lot of public backlash towards the Supreme Court. So I wonder, in thinking about the protection of individual rights, the role of the court in safeguarding the rule of law, and how that interacts with the people, whether you see something different happening in the American context.
No, I mean, I agree pretty much with what's been said. Populism, the people are good. The elites are bad. And then in its worst form, and the elites are, fill in the blank. Okay, we've seen that one. And no one, after 2 minutes thought, wants to go near it. But that's there. Okay. And what about the populism? This document, which I still have in my pocket, the Constitution of the United States, look, big letters here. We the people. That's good. And it's important for a variety of interpretive reasons, which I'll spare you. But why did this document, which doesn't say it, give the judges the power to say a law written by the people's representatives in Congress is contrary to the document? The best thing to read there is Hamilton, Federalist 78. He explains it. He says, this is a beautiful document. Well, he wrote it a little bit conceited. But he's right. It is. It is. But he said somebody better watch over whether the government is actually staying within its bounds. Mm-hmm. Who? The president? He'll just say whatever he does is right. Congress? Well, some countries do that, not so bad. They're elected by the people. But I read into this, though he does 78. Sure, Congress, yeah, they're great at knowing what's popular. If they didn't know what's popular, they wouldn't be in their jobs very long. And they are experts on popularity, believe me. But this document is meant to give exactly the same rights and powers to the least popular person in the United States as the most popular. So Congress won't do. So let's call in the judges. Do they know the answer? Nowhere does it say that they have the answer to every question. Nowhere in 78. But they do know something about law, but it isn't that. He says they don't have the power of the purse, they don't have the power of the sword, so they won't cause too much trouble. So it's sort of, can't think anybody better. We'll give this power to the judges. So they've had it, all right? They've had it. Now, I think it's a very interesting question, this communitarian question, because some of the words in this document do, in fact, protect individual rights. But not all. Some protect community rights. Well, what? A good one is freedom of religion and the establishment of religion And a good book was written by Lord Radcliffe called The Law and Its Compass, in some lectures at Northwestern, and he thinks that basically this whole thing, and law itself was for many years founded in religion, but after a few pretty bloody experiences in the 17th century, they thought 16th, 17th century, maybe we ought to have a rule which says you practice your religion and I'll practice mine and you teach it to your children and mine. But you still have to be careful of having laws that will wreck the ability of people to get together in religious groups. And others, you look at that First Amendment, it seems individual. I can speak freely, but read the whole thing. No, it's done in part, I would say, and others have said. You know, you start freedom of thought, that's religion then, and then you go to freedom of speech, yeah, but you speak, if you want. You could keep your thoughts to yourself if you want. But then press, so it's spread around. And from press, you meet. You see, people find out what you're thinking. And then you petition Congress. So it's a way of developing a public opinion. The public opinion will affect the elected representatives. It's part of a democracy. And then if you really want to trace it back, go back to the Greeks. And you see that the amazing thing about the Greeks was that the Greeks allowed laws to be made through participation of all the people, of course not all the people, but all the people who were, okay? And there we have a notion of democracy that is well beyond individuals. Now, court, of course you should protect, in my opinion, and they will to some degree. The right to vote. Be sure people can form public opinion. Be sure they're out there with religion. There are both parts of this, and be careful, your last point, a good point. Don't go too far too fast. And remember what this is, to me, it is what we call the frontier. It is boundary setting. The people who make the laws are the people who act within those boundaries, and those boundaries aren't very restrictive. I used to listen when I was 5 years old. I'm sorry most of you weren't around, but he was, and I wish he'd listened to it. It was called Sergeant Preston of the Yukon. Sergeant Preston was out there at the frontier of Alaska and Canada, and it's pretty cold, and it's a very tough place. And hey, it's a boundary. Boundaries. Is abortion inside or outside? And to what extent? But within those boundaries, which are very, very, very broad, it is up to the people exercising their voting rights to decide what kind of city, state, town, country they want. Now, that's a whole complicated system, and that's a system that combines positive rights, active rights, passive rights, individual rights, and we hope that out of that will grow an educated democracy where people decide basically what kind they want. Well, we're not threatened yet here to the point where people don't follow the law. They follow it, pretty much. And so, is that threat there on the horizon? Yeah, I think it is. I think it is, but I'll leave that for the future discussion.
Okay, thank you. I would like to come back to several of these themes that have been only briefly touched on, from reproductive rights to executive power to how to respond to some of these threats. But maybe before doing so, we could talk about the role of supranational institutions. We've been talking about individual rights versus communities, certain forms of publics or demos, but we also have in all of your experience, different kinds of either federalist institutions or supranational institutions. Justice Garmentine, maybe you could start us thinking about how courts like the European Court of Human Rights or other supranational institutions intervene in this conversation with respect to protecting individual rights, but at the same time having to respect the democratic publics of member states, and thinking about that balance that's struck and how it can be achieved.
Thank you very much. First of all, I'd like to say that I agree with most of the former interventions, so my role is easier than the role of my colleagues. The supranational, I would not use the word supranational because this is a word that is very, very dangerous for the sovereignists. And they become nervous with this word. But I would say the international courts and, of course, the European Court of Human Rights is an international court. And I would say that it is the last hope of individuals in Europe to see the rights respected. The European Court of Human Rights has a lot of problems, this is true, but this is the last hope of the people. And it is interesting that in countries where people know, where individuals know, that the judgments and the decisions of the court, of our court, are not going to be executed, are not going to be implemented, people still continue to apply to our court. That means it's important for them to have a judgment saying that their state violates a certain individual right. This is very important. A problem that, as I said, we have many problems now. And the populism for an international court is a huge problem because the populist governments are usually very sovereignist. And they start a campaign against this type of courts. For instance, in Hungary, Poland, it's not, we talk always about Hungary and Poland, but it's not only Hungary and Poland. Czech Republic, Slovakia, and other countries, they make a campaign against all the judgments of our court, for instance, on LGBTI rights, on gender rights, on everything that is against them, that is against the thought, the way they thought and the way they think that it is the better way. I think that populism is very, very dangerous to domestic courts, but it's also very dangerous to international courts. I have both experiences, and as constitutional lawyer, as constitutional judge, sorry, I have also the experience of producing the decisions that were against the government. I was judge at the Constitutional Court during the crisis, the financial and the euro crisis. And many austerity measures were challenged in our court. And the Portuguese Constitutional Court was one of the few countries who declared unconstitutional some provisions of the budgetary law, because the austerity measures were included in budgetary law. And I have to say that in Portugal at that time, there wasn't any problem of populism. We haven't yet a populist party, but the leader of the party of the government, the parliamentary leader, made some declarations in the press and in Twitter and in all these social medias, etc., saying things like we have to scrutinize better the constitutional judges. Perhaps the election by the parliament is not enough. They are not following the party who designated or who indicated them, and it was a campaign against some judges. For instance, some of them saw the private life completely. They published things about the private life and things like that. And we were not living in a populist country. We were not. Our prime minister at that time was not populist. So this is to say that even in liberal democracies, the courts, when they are not acting according to the status quo, they are always criticized. We were very, very criticized. The European Court of Human Rights now is very criticized for some part of the good of this kind of things is that there are some that who criticize and there are others who support. So it's not a very bad thing, but it is very easy to diminish, to dismantle the court. For instance, for the funds. The European Court of Human Rights has no funds. The funds are the funds that the states give to us. So if we are not acting according to the will of all the states, the funds will be cut. Another problem for an international court is the possibility of the states to withdraw. United Kingdom is threatening for years that they are going to withdraw. So it's for an international. Russian was expelled. Suspended. No, expelled. Now it was suspending beforehand, but now it is expelled. This is different. But the question is that the international courts, in my view, are even worse than the domestic courts because we depend on many factors and many different legal cultures, many different political cultures, and it's very difficult to find a common understanding even between the judges. So it's not the culture, the legal culture, it's not the same. I think that I stay here and I give the floor to another colleague.
I'm curious to hear, that's sort of the perspective from both the Constitutional Court of a country and then as well from the European Court of Human Rights and but for those who've also served at both levels in other countries, I'm curious, Justice Baer, Justice Amato, does having the European institutions, in some sense, superintending the work of the national courts that you've served on, but in some sense standing apart, influence some of these questions about protecting individual rights versus ascertaining what the community is in terms of striking those balances, or is it still very much a national project with respect to the rule of law in your experience? Both of you.
No, I want to go back to this point. the relationship between individual rights, community, social protection, interaction, recognizing the other, etc., etc. Now, it's beyond doubt that in our constitutions, mostly for the time when they were written, for the cultures prevailing at the time, individual rights are both instruments to protect the individual and also somehow to promote the relationship between me and you, between a group and the other, etc., etc. And the point of the First Amendment and religions, it is so intertwined because you have both religions and religious opinions. No establishment of religions, but freedom of individuals and associations to express their religious views, etc., etc., etc. Now, this is beyond any reasonable doubt. The fact of the matter is that some years later, for several reasons that have to do with the individualizations of lives in urban contexts, with the new technologies, with expectations of individuals growing, etc., etc., with bowling alone, would one of our friends remind us of, etc. Individuals tend to have desires that reflect their own expectations only, not with the others, but independently of the others. I want to decide when I have to die. I want to decide whether I have to be treated or not. It's my decision to say whether a doctor should put his or her hands upon me. It is my decision whether I want to have a child, with a woman or without a woman, with my partner or with a girl that I find in Bangladesh and in Canada. It is my personal freedom to deal with anybody else to have whatever I want. So we are pressed by these demands. And there are legal passwords that allow these demands to be presented as individual rights. The 14th Amendment of the US Constitution, that nobody can be deprived by the states of liberty, life, property, etc., without due process of law, has become something else. The right to privacy, that initially meant right not to let my private life known by others, sort of respect of my privacy, has become my right to decide about my life without external interferences. And this is almost literally written in Article 8 of the European Convention of Human Rights of 1950. Connecting this kind of legal schemes with the new life of people who are bowling alone, and the new technologies that allow to do without the others things that once upon a time needed the others to be done, has created a sort of string of new individual expectations or rights. The courts are facing this problem. Put this thing here. Another thing is that authoritarian regimes of the world, Russia first of all, are saying that they are much better than the valueless Western societies. And the valueless Western societies are such because they care only of these individual rights and not of the good of the community, of our good traditions that are against all of these new things. Now, these feelings enter our societies. There are populist movements who perhaps they don't even care about the substantive meaning of these things, but it might be popular. It might be useful to get political consensus. And therefore, the courts become the first enemies. Why? Because these new expectations or right go to courts, don't go to parliament. Because if I have an article of the convention or an article of the constitution to rely upon, I go to court. And therefore our courts are called upon to give the first answer. Let me say this, that the issue here is not who has the last word, but who has the first word. So if one of our courts says, okay, this is a right of yours. You are entitled to marry a person of your own sex because it's your decision and there is no collective value that is at risk because of your decision. You can do it before any parliament has decided this thing. But it is so easy at that point to say, but who has elected these people? Why do they decide this thing? This is an extraordinary change in our individual and collective life. The courts? Who are the courts to take this decision? And you know, this is how it works. So we are facing this sort of trembling of the architecture of the rule of law. On the one side, for reason of substance. On the other side, because the criticism goes against the courts. So the question is, what should the court do it? Should they withdraw? Should they be cautious? Now the discussion becomes interesting.
Yeah.
Okay, Stefan.
Two articles that I've read. Gay rights. That's certainly one example. Right to die. And what people will say, a group of people, who in perfectly good faith. The article I read was a Democratic candidate lost in Oklahoma some years ago. And he went to meetings with the Republican candidate, and he said, what were the people thinking? Why weren't they voting for me, who am so wonderful? Okay? And the reasons were interesting. He says, the reasons that they're not voting for me is they're frightened. And what are they frightened of? One, they're frightened that what gay rights will do, this was before gay rights, but it will destroy the moral basis of their community. And the same with right to die. You see, it will destroy the sacredness of human life, and that will have a bad impact on the way we live our lives. And you can think of quite a few like that, quite a few. And if I want to discredit that thinking, all I have to do is say that's just how people thought in Reconstruction and Jim Crow, if I want to discredit it. But the third thing they're afraid of is Hollywood. Because they say what Hollywood means is that my children will not live the stable kind of life, marriage, children, stay in one place, that I have lived. And that fear is what creates it. Now, my response to that is it isn't the courts that have done this. If you don't like it, go read the second article. And he points to about 4 or 5 things that have happened in my lifetime. You may not even know them. One is the downgrading of religion. A second is what you said, bowling alone. A third one is what you said, well, implied through the second, technology, because when I grew up, we bought gasoline at the gas station from a gas station attendant, and we always went to the same one. So I got to know him. I mean, maybe we didn't go to parties together, who cares? You saw the person as an individual, and now you don't, because no one can make friends with a slot machine, okay? And there are others. There are others like that. So I look out and say, hey, please don't blame me. Of course, they do blame me. But nonetheless, don't blame me. Look at the change in social conditions. Look at the change, all those 5 things. I only mentioned 3. There are a couple others. But bowling alone is certainly a big one. And, okay, I say, we operate the courts within that social environment. And maybe it's true that the court never would have and never could have decided the gay rights case 40 years ago. But I wish you could have been there with me and read the briefs. And read the briefs on the other side, because I look at the briefs on the other side and I say the arguments against the gay rights thing, in my mind, others thought differently perhaps, but no, they don't fly. They just don't fly. These are human beings, you see, these are human beings. There are a lot of other things in this. But I'm just saying the courts come in later. And now we're at the question that is the hardest, that I always try to avoid in any group. I really try to avoid it. And to what extent are political and social circumstances shaping the mind of the judge? And why do I avoid it? Because on the one hand, I'm sure it's there. And really, I don't know. I don't know. I just know the world I live in. And it's easy to look back. You say, how could they have ever decided Plessy and Ferguson? Indeed, how? But I'm me saying that. Now, today. I don't think they were right for 1 second. But you see, there is the environment. And now what President Amato has said, which is absolutely true, is that's picked on by people. That's picked on by people who want to promote a form of populism. And I've tried to say it in a way that it would just have enough resonance that you could begin to see how people could use that. And they could use it against the courts. And what's worrying to us is they could use it against the rule of law. And what's that? The rule of law. Can I add one extra thing? Okay. To me, one of the most interesting questions I got in my office in Washington was the president of the Supreme Court of Ghana. And we were having a discussion. She was visiting Washington. She wanted to know about the Supreme Court. And she asked me this question. She said, why do people do what you say? Why? Why do people do what you say? Uh-huh. That is a pretty good question. And I can answer it cheaply by saying it's a question of custom, history, da-da-da. But I'll give her, and I'll stop now, because I won't, if we get into this, I'll tell you more detail. But it is the custom, et cetera, and I can give you examples. And I can give you examples that show how over a long period of time, it takes a long period of time before who? Not the judges. The judges say do it. Everybody else thinks, of course, they're self-interested. They get paid their measly pittance for supporting that. It's not even the lawyers. They make their living out of it. Contrary to popular belief, 330 million of America's 331 million people are not lawyers. And yeah, correct. And they're the ones that have to understand the importance of following a rule of law when, by the way, that rule of law is wrong. I mean, if it's 5-4, somebody's wrong. Yeah. Okay? So what are you going to do about that case? Which you don't like, which really affects you, and which may well be wrong. Uh-huh. So I said to her, Go to the villages, the towns, the others, and you go. And they're the ones you have to convince. And it's not so easy to do. All right, I'll stop.
It's not so easy to do.
No, it's not. Okay, now I've sort of fleshed out my own view of this problem.
Well, and in addition to thinking about the sort of Supreme Court or Supreme Courts in some sense as scapegoat for technological or societal change, right, for imposing certain kinds of constraints that they're not in fact responsible for, there's an interesting question, I think, in some of these remarks about what constitutes an individual right versus what constitutes representation of communal interests or community, things get categorized one way or the other, but often we could disagree. And Justice Barrett, in addition to discussing these issues, you've written that attacks on sex and gender equality are also attacks on democratic constitutionalism, which suggests, I think, a different way to think about some of these relationships between individual rights, communal welfare. They could be cashed out through proportionality review, perhaps in a judicial context, but also when we're thinking about societal change with respect to LGBTQ rights, with respect to women's rights, with respect to reproductive rights, with respect to a lot of these contentious questions that courts may get blamed for their intervention with respect to. How do we think about assigning individual rights labels, community labels, constitutional labels? How should we think about these relationships?
I can give you my own answers to those questions, which I think are just fabulous. And but of course you treat individual, et cetera, et cetera.
Okay,
but what's interesting to me...
And then I'm going to turn to Justice Baer, too, because I promised I was going to interrupt Justice Breyer, which is taking a lot for me to actually interrupt you, but I'm doing it.
What's interesting to me is that among these 331 million people are every group under the sun. And unless you have from below, from not the judges, from the people who aren't, enough support for certain views that I can write down and you do too, you're not going to get it. My friend, you're not going to get it. And if you say, very interesting, we'll put his book down there under the bottom of the bookcase at the basement of the library, and maybe somebody will read it sometime. And what we're actually facing, you and me and all of us, we're actually facing a situation where we make the decisions against a background, and we're nervous about that background at this moment, I think. You think? What do you think?
So what are we looking at exactly? We're not looking at simply blaming courts for unpopular decisions. We're not looking at, problematic issues where people think, who are these lawyers to decide that it's way too complicated for them, they're only lawyers, et cetera, et cetera. We're not looking at the usual type of judicial review critique. I think the situation is way more urgent and way more dangerous. I cannot judge the situations in this country, but comparatively speaking, across Europe, across the world, it's way more dangerous than that. We're not only discussing the typical judicial review problem. We're discussing a very strategic, extremely well-funded, globally organized attack on democracy, which starts, and this is no coincidence, with the free press, the academy, by the way, this is where we are here right now, I assume, the academy, and courts. And why is that? Because these are the three forces that hinder an unlimited use of power, which comes in the name and is framed in the name of the people and the general will and the truth and whatever, but in fact destroys the very foundation of what we agreed upon as our democratic way of living together. So what we're facing is this deliberate, well-funded, strategized, globally interconnected, and I'm talking networks, I'm talking real money, I'm not talking an idea out there, I'm talking a strategy of people who have a clear interest, a greedy interest, by the way, there's profit to make, a greedy interest in destroying these institutions to get somewhere else, to get to what I think Giuliano Amato said, an unlimited use of their powers no matter what. And then they start doing this by blaming courts, in particular with particular codes, and I think you said that. They code their attacks in particular ways, to use the ressentiment. people have on their minds anyways, because the situations of our lives became so complicated, because people really would like some kind of normality in which to bring up their children. This is why gender, meaning sexism in the most archaic patriarchal form, is so high on the agenda. It took me a long time to understand, why are they so into gender issues? I mean, you know, I thought they'd do like some, you know, economics something or whatever, but why is gender so high? Because gender can activate each and every one of you in a second, right? I can only say gender, and some of you will be activated already. Then I would say LGBT or whatever, but some issue is with each and every one of you, and all the moral commitments and the normality assumptions and the who am I and who am I attracted to and what will my life be and who's my mother, blah, 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 is all on the table right away. So it works really well. Suicide, euthanasia issues are a little bit similar, but what works even better is racism. And I call it that. It's not just some migration disagreement, policy disagreement. It's outright colonial racism. And that racism also triggers right away so many things you cannot really say, but you have in the back of your minds. And so they work with that. So they code a large attack on democracy to establish an autocratic regime, named law, but has nothing to do with law that I would call law anymore, with these ressentiment charged items on their list to, you know, get, in Hungary, there's a wonderful analysis out there on what the Orban government was after. Well, money, unlimited power for their families, et cetera, et cetera. So there are real interests behind that. I'm not interested in the interests, I'm interested in what's happening. So they code things with the ressentiment issues to go after democracy, which is all of you, all of us, right there in your lives, but they target the press, because we all know the press. I mean, the press has problems, and those journalists and da-da-da-da-da. They target the academy because, you know, gender studies. Why should one pay for that one? And they target the courts because, you know, with the courts we all know. I mean, how dare they? Who are they? What about democratic legitimation, et cetera, et cetera, et cetera. With international courts, extremely high on their list because who are they? I mean, they're not even us. Who elected them anyways? They don't talk or speak our language properly. They don't understand a thing about our country. So who is a European court, an inter-American court, some UN institution even further away? So what I'm trying to say, there's a strategy there. And the strategy works because in the back of our heads, there are many things which are not entirely clear. So when Stephen Breyer quotes, you know, the Federalist Papers and says, you know, the courts are there to set the boundary for an agenda for you people to vote people into Congresses, parliaments, etc., to play on that playground, and the courts watch the boundaries. Yeah, to me it makes total sense, clear, end of discussion. Well, to many people, there are a lot of question marks in there and a lot of kind of insecurity and a lot of things, and then I got it back to us, which we have not properly conveyed to people, which law schools, politicians, people in public office, anyone should be very clear about, because otherwise we will not be able to counter these attacks because they're well-funded, strategized. They're also way beyond us on all social media. The Open Society Foundation once started to count how many right-wing strategized efforts are on social media compared to kind of liberal voices. It's outrageous. They're way, way, way more than anything we can ever mobilize. So we have to prepare and understand the codes used to attack the very foundations of where we are. For courts, there's a lot of things I think courts have to do better. One is, to respond to your question last sentence, is that national courts need to understand themselves as part of a global scheme of actors, states, people committed to democracy and the rule of law, which means in our work, and I know the Italian court, the European Court of Human Rights, many, many national courts do that, and Stephen wrote a whole book about even American courts going a little more global. We do that. I'm a proud member of a court who does that for ages now, and to systematically say, I swore my oath on the German Constitution and only the German Constitution, but the German Constitution is embedded in the European system, sure, but also in the United Nations system. So in every case, what I check for, and this is a good check, an internal check for a judge who would maybe go off, to some ideological island otherwise, I cannot go to that island because I have to, when I interpret my law, at the same time look at the European conventions around me, the ratified UN conventions around me. Yes, there's a problem when states leave these conventions, like Turkey left the Istanbul Convention or others, but after all, there is a United Nations consensus. There's also a consensus on soft law, et cetera, et cetera. So I have many sources to back up my own efforts, to back them up, to make this effort stronger and still be utterly national, but embedded internationally. So I think this is part of a response courts need to work on and establish more strongly to fight the populists, because the populists tap into way stronger codes out there. So we have to kind of weaponize ourselves. I don't usually use such martial, is it martial? Well, words, but there's something to back ourselves up with, I think, an embeddedness in international law, United Nations commitments, and those more recent developments. Because on our own, we're pretty lost out there. We need the people, and we need an international community of courts and actors who are as committed as we are to the rule of law and democracy, to really fight that fight. It's a fight. It's not a discussion anymore. It's a serious fight. So.
Do you want to offer more? Oh. Does the same hold with respect to international institutions in terms of that sort of weaponization?
I fully agree with Suzanne, with Professor Baer. I fully agree. The problem is that, in my view, the populism started step by step many years ago. And this is very interesting because, in my view, the successive crises that we had in the world and the response that the governments gave to them, and the fight that the governments had between them, for instance, during the financial crisis. You remember Germany and Netherlands and the Nordic countries saying that the countries of the South were not competent to manage the money and to do things. And it starts like that. In the European Union, for instance, the member states start to fight one to each other. And in my view, the populists saw this and they saw that, and they thought, okay, this is here, a small open door to do something. And of course, you are completely right. This is a global, and in our country, in our court, we are very very aware of this problem. The problem is that we are very aware, but sometimes we cannot do that much. But I think that these ideas, the difference that the judges should have or must have before the governments and the parliaments and all these things. The principle of subsidiarity, this is a principle that means the court is going to act only when the domestic courts don't do their work, and the margin of appreciation of the states, and so on and so on. I think that these principles should or must change a little bit. Because if we are always different to the governments, and if we accept everything that the governments do, even if they act against the convention, and the convention is a living instrument. This is very interesting. We are in the USA, and for me it's very difficult to understand all these theories, historical theories, the interpretation of the Constitution as it was 2 centuries ago. This is a discussion that in Europe we don't have that much this discussion, or at least we have lots of scholars and judges and supporting the opposite idea. The law is not static. The law must adapt to the society and to the evolution of the society. And in my view, there are some achievements that we cannot lose. For instance, for me, the right of abortion, or in Portugal, the marriage between same-sex people and other rights, when they are considered to be rights, I think that the step back is a huge problem. That means, for me, I don't see the law as, okay, today we have the right and tomorrow we don't have the right. It depends on the parliaments. It's not like this, because the people who are involved in these rights, in my view, the people who are involved in these rights, they cannot, one day have the rights and the day after don't have the rights. So for me, this is very complicated. But of course, I am pretty isolated in this opinion. I remember when we declared the same-sex people marriage according to the Constitution, when some of my colleagues, the reason why they considered that it was not unconstitutional was because it could be another decision in the future. For me, it's not possible to have another decision in the future in this contest. There are people involved. There are the droit acquis, acquired rights, and this is very complicated. So this is my opinion. Thank you very much.
Well, thank you. I have many more questions, but I'm noticing that we are getting short on time, and I promised our audience the chance to ask questions. So I'm going to turn to the audience now, and there are some students with microphones who can come around, and I'll just ask that when I call on me, you could please briefly introduce yourself before asking your questions so we know who you are. Yes, right. Yes, of course. They're bringing you a mic right now.
Here, I'll just hold it for you.
Okay, very good.
Oh, you will hold it?
And yeah,
I
maybe you
won't be
could
singing.
stand up also.
Can you hear me? Yeah. Thank you. My name is Wilson. I'm a private consultant. Question is, if you can give me your insights, I mean, all of you, on information disclosure, ethics, rule of law, the people now, and I wish Justice Breyer can start with that question. Thank you.
Thanks.
Yeah, because I felt I was too negative. See, I just gave you the negative side. And I can learn the negative side because we have these briefs. I don't know why they're called brief. They're not. But regardless, you get a lot of different points of view. All right? So let me give you, since we've been pretty negative, what I find, and makes me, at least in this country, basically positive. I'm basically positive because I talk to a lot of students, different universities, law schools, etc. And I make sure I tell them at least the following. That I talked about the Ghana woman who was doing a good job, and what I told her was in the 1840s, the Supreme Court said that northern Georgia belongs to the Indians, and gold was found, and the Georgians grabbed it, and the Supreme Court said it's the Indians, it's the Cherokees, it's not, it's not the Georgians, and the President of the United States said John Marshall's made his decision, now let him enforce it. And he sent troops, but not to enforce the decision, but to drive out the Indians who followed the Trail of Tears, all right, to Oklahoma, where they live to this day. And we're all aware of the Civil War and Reconstruction and so forth. And the case that I always find fascinating was Cooper versus Aaron after Brown, where in Little Rock, they wouldn't let those 9 black brave children into the school, and the President of the United States sent 1,000 paratroopers. Bravo. And they took them by the hand. It was 101st Airborne. We all knew who they were. They were the ones who'd been hung up on the steeples in Normandy in the Battle of the Bulge and so forth. And they brought them right in the school. But the story doesn't end, because they couldn't stay there forever, right? They left, and Governor Faubus closed the school. And a lot of other places in the South did too. So, 9 justices of the Supreme Court said you got to send them to school. No, he didn't. All right, but it was too late. The reason it was too late and did not last forever, in my opinion, and the school reopened, was because we had reached the stage of, use a word that's not supposed to be, they had awakened the country, a lot of it. And they'd said there was Martin Luther King, there was Rosa Parks, there was the Freedom Riders, and we lived through a lot, and it wasn't tough, and it was tough, and it wasn't easy. But eventually, legal segregation came to an end there after people who weren't lawyers and judges began to understand. I heard Senator Reid, the Democratic leader, after our court had decided Bush v. Gore, you probably know what Bush v. Gore was, and he said, et cetera. I dissented Bush v. Gore, but what I heard him say is the most remarkable thing about that opinion is rarely remarked, and that is that even though a lot of people in this country affected them, and they thought it was wrong, at least half did, and sometimes I say maybe a few more than half, and maybe it was wrong, but no rocks, no stones, no guns, no riots. And at Stanford, I was giving this pretty stock speech, and I said, I know 30% of you are thinking, too bad there weren't any riots. I say, before you come to that conclusion, turn on your television set and go look at what happens in countries that decide to resolve their differences that way. Yeah, that persuades a few. And why? I worked for Senator Kennedy for a few years. What Kennedy used to say, and I tell them this, and that's the point, I'm sorry I'm banging on, but I think it's an important point. I tell the students what Kennedy told me. He says, you go out there when people disagree with you on the other side, and the first thing you do, after looking in the mirror to see that you're not part of the problem, you go and listen to them. You talk to them. Keep your mouth shut. Listen to what they say. And if they talk long enough, you will discover that there are things you agree about. And when they hear that, you say, let's work with that. And then you try. You don't always succeed, but if you get 20%, that's a much, much better result than 100% of nothing, where your normal followers will say how great you are. No, you want the 20%. So you go out. John Stuart Mill did that. Find people who disagree with you. Find what they think. Talk to them. And if you get that 20%, and I saw him do this a lot, the newspapers come in and they say to Senator Kennedy, you did a great job getting that through. He says, I didn't do it. It was Orrin Hatch. It was the Republicans. They had the idea there. Credit is a weapon. If in fact you get somewhere, there'll be plenty of credit to go around. And if you don't, who wants the credit? But I saw this over and over and over, and I saw it bring people together. Now, my speech is not my point. My speech is over and over. I add to this, we, at least in the United States, and I think in other places, are not so bad at getting people of different views together to deal with a problem. In Cambridge, Massachusetts, there were plenty of groups that went around during COVID and looked for old people who needed food, and that wasn't restricted to Cambridge. That was true in St. Louis, that was true in San Diego, that was true in New York City, that was true, you name it. Okay? So it isn't so hopeless. So my point, and again, I point out, it's not what I say, it's when I say it, I see my audience. And my audience of those students, it's a plus. It's a plus. They like the idea. They like these ideas. And why were they so negative before? Because they couldn't think of a place to go. And now suddenly they see. They see it's up to them. And that's why I say, it's not up to me anymore. I'm sorry, it's up to you. And so here are a few things you can do. Here are a few things you can do over and over and over. Over and over and over. And maybe you first get 10% or 20% or 30%. But we're used to that in a country of many, many different kinds of people. And we got to bring them together. And so I say, that's my point. It's up to you, my friends, now. It's up to you to keep us together. I think you can do it. And judging from their faces, they think they can do it too.
So, okay, even though that would be a lovely last sentiment, I feel obliged to give our audience one more crack. So, and since we have a lot of hands and we're not going to have a lot of time, maybe we can group 3 questions, and I'll test the panelists' memories to see if we can respond to those questions. So, you right there, and then I'll come over to you, and then I'll come over to you, okay? So, someone have the mic still? Oh, sorry. You right here. You want to stand up? Yeah. Yeah. Great. Thanks. I know it's a lot.
Hi, my name is Emma. I'm a senior at Barnard College, and I'm from Cambridge, Massachusetts. So I appreciate the shout out. Perhaps you could have anticipated this question, but I was wondering what you would say in response to people these days saying that members of the highest courts of different lands are perhaps more influenced by politics and partisanship than we would like and we would hope. And how can we keep courts independent from increasingly partisan political bodies? Thank you.
Thank you. And maybe for mic management, actually, we'll come to you next, and then we'll come over to you last.
Hi, I'm Christina Kagina, and I'm one of the million. I'm an attorney. And my question is, do the courts, and this is for all of the panelists if they can, tell us the role of robust and well-funded public defense in the issue of populists, fighting populists, and if you feel like that's one of the points of attack that seems to be happening. I can tell from my perspective what might be, but I'd like to know from an international and certainly from Justice Breyer what his viewpoint on that is.
Thank you. And last, yeah.
Hi there. My name is Shreyas Kumar. Thank you so much for speaking. My question follows up on the first question, kind of more about the role of the courts in kind of maintaining a sense of ethics and principles, and not only in the manner in which it's kind of been inevitably intertwined in politics, but also more about the way of managing the adherence and of certain legal theories that are taken on, as well as other jurisprudences that are upheld that might be in disagreement with the other branches of the corresponding countries and entities.
Okay. Thank you all. So maybe we can just do a lightning round.
There is a gender balance here. I want Susan to answer.
All of them.
No
pressure.
And she won't.
Okay.
But these are great questions and complicated ones. So we will only be able to shed some light on some aspects of them. How to make courts less partisan and what is the role of public and well-funded defense? I think they connect very well, because courts need wise and smart institutional design, and not all courts are designed the same way, and they're internationally compared better and worse ones, I should say. However, each court functions in their political culture and environment, so it's also not easy to compare them. So you cannot say, the appointment procedure in this country would be the best for all of them. They're usually not. It very much depends. However, coming from a court with limited terms, with partisan proposals for judges, justices, but a high majority requirement, a 2/3 majority requirement to vote them in by Parliament or the second chamber, seems historically to be not the worst idea, because it ensures that no one side can appoint their candidates without at least the agreement, talking to the other side and listening to what they think, the agreement of the other side, at least in a functioning party system. So those mechanisms in the appointment procedures, in the selection procedures, selection of international courts is a big one. Diversity, to ensure diversity on the bench, both regarding viewpoints, regarding experience, regarding professional background, which is, I'm saying, way more than gender, but gender is certainly a start. To ensure diversity on the bench is a big one to make courts less partisan. And yet, I think what I should note from my perspective is I was proposed by the Green Party. I'm not a member, but most of my conservative colleagues are members of the Conservative Party. Everybody knows. It is suicidal for a judge to deliver on that membership. So what historically happened is that usually the first few decisions a new justice takes were sort of going against their party opinion or against that memory. That's not always true. There is a leaning, and that leaning is wanted. So certainly people would have been totally disappointed if I would have been an anti-ecological, anti-feminist, and anti-discrimination person. They expected me to be that. But, there's a lot of space to fill that role. So to be honest about partisan leaning and yet expect a judge then to be the judge and not to create a taboo that judges are from some other planet and have no partisan leanings, I think is a good idea. To remove the taboo, to be honest about our situatedness in contexts, with experience, with professions, with a background, with a family, or no family, or whatever. That is important, but to, at the same time, call on the judges not to fall for that. For law students in the room, to call on your courts to be good in judging, meaning follow doctrine, argue legally and not morally, do not insert religion into your arguments, etc., is a very good idea. Good critical assessments, like productive criticism of courts, is a very good idea to make courts less partisan, because if you call out of them naming and shaming, I think people in the United Nations will know that concept, naming and shaming is a good idea. Again, however, siding with Stephen Breyer, attack is not. So I'm calling for productive critique. It can be sharp, it can be, but it shouldn't assume that some judge didn't properly think about the issue. That's things we sometimes read about ourselves, and I'm like, oh my God, I'm bored. Did you read those few thousand pages of briefs yourself? I mean, did you read the full judgment? Whatever. So productive criticism is really something one should use. Role of defense, good lawyering is essential for courts. Having all the perspectives out there, and particularly expertise, and particularly in a world where we're in a crisis of the truth, in a crisis of facts, we need to navigate an assessment of reality where we need defenders and lawyers and litigants who provide us with access to information, with criteria, with a lot of viewpoints. So without good lawyering and perfect defenders, there is no good acting of courts. So I think it is an essential component of the justice system. In the United Nations efforts to foster the rule of law, to support the rule of law, there are projects which are called My Court. I think it was in Bangladesh or Pakistan, My Court, where they call the courts actors of justice. They're part of the justice system. They're delivery points of justice. And then to deliver justice, they're not alone. They need defenders, they need the lawyers. It's an essential part of the system. So to defend the rule of law would require us to also defend access to justice, which is also defending public defense options, which are then necessarily funded. It's one of the components which are a necessity and not a luxury to have, I think.
Okay. Justice Amato and Justice Martinez, I think you wanted to add a brief word.
I just want to add something very brief. Sometimes in a court, and especially in a human rights court, it's difficult to see where is the conservatism and where is the progressism, if you sometimes I know now more or less who are my colleagues more conservative and who are the colleagues less conservative. But in a case, for instance, where there is a conflict between freedom of press and the right to be forgotten, this is a case we will see the outcome in some weeks. Who is more conservative? Are the judges who support the right to be forgotten, or are the judges who are more concerned with the freedom of press? So sometimes when we think about a partisan court, we think about stereotypes that don't fit in courts at all. This is my experience as judge at domestic level and as judge at an international level.
Just a matter of word.
Just a word on the issue of courts, their roles. You see, when an issue is very controversial and it arrives to you before arriving to the parliament, you have the sense that saying the first word, is it for me? Well, sometimes it is, and you feel that it is, because there are changes already visible in your society, and you can say, now it is so. Let's say, something that I really enjoyed, it was in the Obergefell decision, the decision on same-sex marriage, using the Loving case as a precedent. This was extraordinary for the court. The Loving precedent, Loving was the case in which the court said, Supreme Court of the US several decades ago, that anybody has the right to marry anybody else, free choice. And so they could be yellow and white, tall and small, white and black. And there was a statute of Virginia that prohibited white people to marry black people, and vice versa, obviously. This law was against the federal constitution. Nobody said no. Nobody could react against this. This was the precedent for this other case. And this demonstrated that, according to the court, this was equally not disputable. Everybody has the right to marry everybody else. It is a free choice. Let's say, another short example. We, the Italian court, we found ourselves with the first instance in which assisted suicide was brought to our attention as something that should not be punished. Why our criminal law provided for any form of assistance of a suicide as a crime. The case we decided was a case in which it was a terminal person, the last part of his life, he was a male, suffering, no kind of treatment could reduce the suffer. Artificial life with machinery allowing him to remain in life. He said, there is no dignity in my life now. Let me go. Help me to go. And we said, it is against the Constitution that this man cannot be aided in leaving this world. So sometimes you feel that your first word is the right word. Sometimes it is not so. Sometimes you feel that it is for others. But in which other cases suicide can be assisted? And other issues that we don't have the time to explore. Now, the real problem nowadays is the fact that our parliaments frequently are prisoners of their extreme. And therefore, they cannot decide what you should do. Your role is today to convince your political representatives that their role is not to have a flag in their hands, but to find a reasonable agreement with others whenever possible. I give you a final example. The situation of abortion in this country, allow me to say it, is absurd, incredible, against any possible reason. On the one side, the defense of Roe versus Wade as it was, with free abortion until the 25th, 26th week, which is something that no one thinks in Europe is reasonable. On the other side, once you have eliminated Roe versus Wade, prohibition of abortion completely, and the life of the mothers at risk to defend to the extreme the life of the child. This is a complete nonsense. The Supreme Court at this point has done what it has done. But in these cases, the real problem is not in the courts, is in the relationship between society and its political representatives. Do not remain in the hands of the extreme. Our job that we tried to exercise for years of finding reasonable accommodations, finding correct balancing, rational balancing, is a job also for parliaments. Do not allow your parliaments to be dominated by the extreme. This is nowadays the real risk of populism.
Thank you, Professor Amato. And please join me in thanking all of our panelists.
This afternoon dedicated to people, rule of law, and Supreme Courts, I would like to thank all of you for being with us today. Ambassadors, Columbia students and faculty, friends of the Italian Academy. I'm grateful to the European Public Law Organization, Professor Flogaitis, for the fruitful partnership, and to Professor Ballman-Posen for her agility as a moderator. Finally, please join me in thanking our honorable speakers for a truly enlightening and inspiring event. Thank you and have a nice evening. Thank you.